Mediation is often court-ordered. It is a requirement or an opportunity for the parties to sit down in a more formal circumstance and say, we're at odds. Using a process, how can we go about resolving those odds? It can take different forms. The one which I think works best is where everybody's in the same room. There are reasons why not to sometimes. Everybody's in the same room with a mediator, right, who's a neutral, and they talk about their relative initial positions. And then they break up into caucuses, and caucuses are important. The plaintiff goes off with the plaintiff's attorney, defense goes off with the defense attorney, and the mediator then shuttles. You've heard of shuttle diplomacy, right? Shuttles between one room or the other and hearing the position of the parties, coming and talking with the other party. Here's the important thing to know. Mediators in mediation are allowed to lie, cheat, and steal. Part of the fair game, right? Because what they're hearing is, here's your position, and here's their position, but the mediator, a good mediator, can track a way to get you guys together in ways that you haven't thought about, novel ways that will work. But everybody's so positionally thinking that they don't see that. So the lie, cheat, and steal say, well, they're saying this when they may or may not be saying that, right? But they see it as a part of the track to get you together. So that is fair game in a mediation. Your attorney needs to be skilled enough to hear the diplomacy, the nuance, the technique in the mediator's presentation to make a calculated assessment on what the mediator is trying to accomplish, what of that is gospel, what of that is completely fictitious, and how to counter in a way that will accomplish the mediator's perception of getting you guys together in a way that still works within the terms that you want to resolve the case. Litigation is the classic plaintiff sits at plaintiff's counsel table with their attorney, defense at defense counsel's table with their attorney, judge sits up there, plaintiff presents their evidence, defense gets to cross-examine the witnesses, defense presents their witnesses, plaintiff gets to cross-examine their witnesses, judge makes a decision. It's all a very contained environment, right? And it is turning over your issue to a third party to make a decision. That works in many cases. Mediation is a different animal where you're making, or you're at least a party to, making the decision yourself. The sweet thing about mediation is that nobody can force you to come to an agreement. So you don't agree unless you agree. That's what makes it so powerful. You have not only skin in the game because you're doing litigation, but you have control of the outcome. Mediation is preferable. The cost differences between mediation and litigation is mediation is a subset of litigation. It is possible to mediate before litigation. I don't think it is a good idea because litigation as the broader context, right? Let's put it in the context of a divorce case. At the end of the divorce case, you need to get the paper that says you're divorced. That is litigation. So you've got to go through that process to get the litigation. You can mediate outside of that, but knowing that at the end of it, if you're successful, you still got to go through the litigation process of getting divorced. The other reason to do it within the context of litigation is that there are guardrails that help make sure that you can trust the mediation process if you're in the context of litigation. There are sanctions available for screwing around with mediation that you don't get if you're just doing it voluntarily. The cost of the two, within mediation, you're doing it hopefully fairly early on in the litigation. So you've expended those costs in litigation up to that point, and if you are successful at mediation, the costs are over. So the question becomes, how soon do you mediate? Is how soon do you stop spending money? In litigation, you're talking about spending money before mediation, spending money at mediation, and spending money after mediation. So let's say that you've got a case going and you paid a $10,000 retainer and you get to a good place where you know the facts and your attorney's saying it's time to mediate and you are $5,000 into the case. Let's say you mediate all day and it costs $2,000. $7,000, you're done. And to the same scenario, you come to mediation, you don't settle, you're going through trial. Next thing you know, $20,000, $30,000, you're done. So you can see how it is much more economical to settle at mediation if you get terms that you can live with, work with, and that money that you have saved in mediation is not money that you would have made up fivefold, tenfold if you'd gone through litigation. In other words, if the other side is giving you a terrible deal and you're sitting there saying, you're offering me $60,000 in alimony, But I'm thinking, my attorney is telling me I should get $300,000 in alimony. Sounds like a pretty good reason to spend another $10,000 or $20,000. So it really is an apples to apples comparison on what's the best use of your money. But if you can settle at mediation within your terms, that's always the better idea. Mediation is always an option. There is never a time not to mediate, because if you think of the worst case scenario, bad abuse, right? There's just terrible abuse. There's a terrible power dynamic in the family. You would think, don't mediate. There are other guardrails in that case. In that case, you will not meet in person. Won't happen, right? Why would a person who represents an abused victim who is still going through the process, I cannot see my abuser, why would you put them in the same room? Nothing good is going to come of that, right? If you don't settle at mediation and you just go to litigation, there is still going to be a moment where the abuser and the abused are in the same room. It's in the courtroom. And there's a whole lot more stressors in the courtroom when you're together than there is in mediation, particularly if you don't have to face the accuser. So you don't get off the hook by saying, we'll go to litigation and not mediation because I won't have to confront the abuser. Given that scenario, it is good to try to take the opportunity under the right circumstances to get a case resolved at mediation, if possible. The other part about it is it can be kind of a trial run. So if you don't get it settled at mediation, it gives your client an opportunity to have a little bit of a panic attack under very safe circumstances, learn some breathing technique, and get more prepared for what then is going to happen if it doesn't settle at mediation when it comes to litigation. So mediation is always an option and should always be taken. If you have any questions about mediation versus litigation, which way you should go, why you should do one, the sequencing of them, give us a call. We're here to help.